Professor Gerald Bamberger. Today we're going to be working a simulated multi-state bar examination type of problem in the area of constitutional law. It's problem ConLaw2. You can find it on my website, www.profbamberger.com. If you haven't already worked problem ConLaw2, why not take a moment, pause this presentation, go over to www.profbamberger.com, spend about 1 minute and 45 seconds working problem ConLaw2, and then return and resume this presentation. Okay, I'm going to assume you've already worked problem ConLaw2 over at my website. The correct answer is choice D. Will Revere succeed? Answer no, because the Secretary of the Treasury is a department head. First, a little tip. When I was a law student, the very first thing we were asked to do in constitutional law class was to read the Constitution. I will admit, for millions of viewers, that I did not read it. And I will also tell you that a lot of my friends in law school at the time didn't read it either. I didn't read the Constitution until after I graduated law school and started teaching law. That's a mistake. First of all, most of the Constitution means what it says. It's pretty straightforward language. If you can't understand it, get an annotated text. Get a civics book, a U.S. government book, a high school or college textbook that has the Constitution with some annotations to clear up anything that's unclear to you. It's really a good idea for you to have read it one time. Number one, because it's readable, and number two, because there are small provisions in the Constitution that you may remember if called upon to do so in a test question that wouldn't otherwise be obvious to you. So, good advice. Read the Constitution at least once. Use an annotated text. It might be helpful. This question here depends entirely on your knowledge of the Appointments Clause, which is found in the U.S. Constitution, Article 2, Section 2, Clause 2. So let's take a moment and read that clause together. Referring to the President of the United States. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate shall appoint, ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. So in the beginning we have a discussion of the treaty power just for a couple of lines, and the rest of Article 2, Section 2, Clause 2 focuses on the appointment power. The power of the executive to appoint executive officers. And there are two types of executive officers. There are the principal officers. Those are nominated by the President, and they are appointed with the advice and consent of the Senate. And the inferior officers. In the case of inferior officers, Congress has the power to vest the appointment of such inferior officers in the President alone, in the courts of law, or in the heads of departments. Let's go back to our problem and see how Article 2, Section 2, Clause 2, the Appointments Clause, is going to apply. Now, we have a board. We have the Hedge Fund Oversight Board, which is going to promulgate a series of regulations that is going to directly affect Paul Revere, who manages a large hedge fund. Rulemaking, the promulgation of regulations, that's an executive function. So the executive branch is going to be responsible for performing that function. The people who are going to perform that function, people who can make rules, are going to be executive officers. So they must be appointed in a way that conforms with Article 2, Section 2, Clause 2. So the question is, are they principal officers or inferior officers? Once we make that determination, we know which type of appointment under Article 2, Section 2, Clause 2 will apply to them. Now, here, it's pretty clear that these are inferior officers. The test for who's inferior and who's principal is probably best laid out in Morrison versus Olson, the independent counsel case. In that case, it was established that an inferior officer is a person who is subordinate to another officer. In addition, some indicia of inferior officers are that they have limited duties, they're limited in jurisdiction, that they're temporary. Here we have a number of these indicia. Clearly the board is subordinated to the chairman of the SEC under the facts we have here. It's got a 5-year duration. Its jurisdiction is limited to the oversight of hedge funds. So clearly we're dealing with inferior officers. Therefore, Congress may vest their appointment in the president alone, in the courts of law, or in the heads of departments. And the remaining question we have will be, has Congress complied with those requirements? Have they, in fact, limited themselves to vesting the appointment in the president, courts of law, heads of departments? The point here is Congress can never appoint an executive officer. If Congress does appoint such a person, they can't function in the executive capacity. That would violate separation of powers. In the famous case Buckley versus Vallejo, Congress attempted to create a federal election commission with 6 members, 2 of which were to be appointed by the President pro tempore of the Senate, 2 of which were to be appointed by the Speaker of the House of Representatives, and 2 of which were to be appointed by the President. The problem with this scheme of appointments was that 4 of the 6 appointees were being directly appointed by members of Congress. Congress can never directly appoint executive officers. At best, if they're inferior officers, Congress can vest their appointment in the President alone, in the courts of law, or in the heads of departments. So in Buckley versus Vallejo, an attempt by Congress to directly appoint executive officers meant that those executive officers would not be able to function in an executive capacity. Why? That would violate separation of powers. Now, here what the Congress has done is it has created a 5-member board. They're inferior officers. 2 of the members are to be appointed by the President. That's fine. 2 of the members are to be appointed by the courts of law. We're told that 2 of the members are to be appointed by the United States Court of Appeals for the Second Circuit, and 1 member is to be appointed by the Secretary of the Treasury. The Department of the Treasury is a department. The Secretary of the Treasury is a department head. So in all 5 cases, Congress has appropriately vested the appointment in the President, in the courts of law, or in the heads of departments. That's why D is the correct answer, because the Secretary of Treasury in particular is a department head. Therefore, Congress has complied with Article 2, Section 2, Clause 2, vested the appointments of these inferior officers in the President, the courts of law, and the heads of departments. Now let's take a look at the incorrect answers. Choice A. Choice A says, will revere succeed? Answer yes, because the Act violates the Appointments Clause of Article 2, Section 2. That's pretty straightforward. We've just proved that it doesn't. So choice A is an incorrect answer. Choice B. Choice B says yes, because the formation of the board exceeds Congress's power under the Commerce Clause. The formation of this board is necessary and proper to Congress's power under the Commerce Clause. Hedge funds operate in interstate commerce. The regulation of hedge funds is proper regulation of interstate commerce. The formation of this board is necessary and proper to the regulation of interstate commerce. No problem there. B is an incorrect answer. Finally, let's take a look at choice C. Choice C says, will revere succeed? No, because this method of appointment under the circumstances is necessary and proper to the exercise of Congress's power to regulate interstate commerce, even though such an appointment scheme is not provided for in Article 2, Section 2. This issue, as a matter of fact, was directly addressed and rejected in Buckley versus Vallejo. In Buckley versus Vallejo, again, we had the issue of Congress appointing a federal election commission. In that area, in the area of the times, places, and manner of holding elections for senators and representatives, according to Buckley versus Vallejo, Congress had been given explicit and plenary authority to regulate that field of activity. Nonetheless, it needed to comply with the Appointments Clause of Article 2, Section 2, Clause 2. So the mere fact that it may be necessary and proper to the commerce power is not enough to trump the Appointments Clause. That's why choice C is an incorrect answer.